Good evening and thank you so much for joining us for another edition of All Angles. I'm Dion Jackson Miller and special welcome to our viewers on onespotmedia.com. Later on in the program, we're going to be talking about whether Jamaican should be an official language or patois as we call it alongside English. And joining us in studio this evening to discuss that, we have with us Member of Parliament Mark Golding. We also have Principal of Mona High Kevin Jones and Professor Emeritus Linguistics Professor Hubert Devonish from the University of the West Indies. First, though, joining me at the board, the smart board here, I have Lloyd McFarlane, who is going to be talking to us about the Tesha Miller verdict. He was found not guilty, I do beg your pardon, guilty yesterday on 2 charges of accessory before and after the fact. We're going to be getting into that in just a moment. First, though, let's just look at some of the timelines, the main points during this trial. It was in June 2008 that Douglas Chambers was murdered. Now, he was then the chairman of the JUTC, and he was actually killed at the entrance of the Spanish Town depot. Now, in 2009, the police had said there were 3 suspects in the case. One of them, they said, had been killed in a gun battle with the police. And then in September 2010, there was someone charged with murder, Andre Bryan. 6 years later, in 2016, he was found not guilty. It was just over a year ago, October 2018, that Tesha Miller was charged in connection with this matter. And as we now know, he was yesterday found guilty on both counts. Lloyd McFarlane, when you listen to it, it sounds like a long time. Douglas Chambers killed as far back as 2008, a verdict yesterday. But when you actually looked at the Tesha Miller case, that really isn't an issue of delay at all. We're talking about a relatively speedy trial here.
The key here is when he was arrested, which is 2018. And if you look at your own timelines here, you'll notice that the person, Andre Bryan, who was arrested in 2010, had his trial in 2016. Now, that 6-year period is really, unfortunately, about average in terms of the time it takes from arrest to trial in our courts because of the severe backlog that we have. Tesha Miller was arrested in 2018. The fact that he is able to have a trial before the end of 2019 is extremely remarkable. At the same time that Miller's trial was going on in Court 2, I had a matter going on in Court 1. And that matter had persons who had been arrested in 2011. And because there were originally 5 of them, it was extremely difficult to get it going. And that type of timeline is what really
That's
we face.
more typical.
Yes.
All right, well, let's talk about then what he actually had been charged with. The law, in law, we speak about principals and accessories. What do those terms mean?
Well, principals are the persons who are actually supposed to have committed the offense. If it is murder, the person who did the killing. The fact, however, is that that is not the only person who can be charged or convicted for the offense of murder. That person is the principal, but you also have what are called secondary parties. Persons who could have been aiding and abetting the principal, or persons who could have been counseling or procuring the particular offense.
Okay, in English now.
Aiding and abetting simply means helping, assisting, the aiding part. Abetting also means counseling or inciting. But when you aid and abet, it is a situation in which you may have what is called a joint enterprise. Several persons go to commit a robbery or whatever it is, and they have different roles. Some of them are the lookout persons, and they are present, but only one person actually does the killing. This person is called the trigger man. But all the others are equally guilty of the offense of murder because they were there to assist and did assist. In terms of procuring, however, that person does not have to be there. However, that person has given substantial assistance in terms of the offense being committed.
Let's get some examples. So suppose, for instance, I hire a hitman to take out somebody.
Now, that would actually be procuring the murder. A simpler example, of course, is if somebody wants to stab or shoot someone, and you go and give them the weapon to do it, but you are not there with them, but you know that their intention is to commit this offense, then you are equally guilty. The point is that...
As guilty as a person who
yes,
did the actual
because
shooting
you are
or
now
stabbing.
charged as a... You can be charged as a principal. If we have cases of aiding and abetting, all persons are usually charged as principals in the same offense, even though they have different roles. Where, however, you have a situation in which someone is said to have procured the murder, a contract killing.
Or given orders, suppose I...
A command. In fact, the statute specifically uses the word command as well. Where you have that, then that person does not have to be present to be charged.
Okay. So I could be sitting in GP, order hit
and
on
make the
somebody.
order. Right. Now, where you have a situation where that person is procuring, they can be charged with murder, but they can also be charged with being an accessory before the fact.
Okay.
Whether they're charged with murder or an accessory before the fact, if they're convicted, it is the same sentence that they face.
Okay, well, I'll get to the sentence in just a moment. So if you're an accessory before the fact, you'd have been involved in the procuring or the planning leading up to the murder?
Yes.
Okay, accessory after the fact now.
That is a lesser situation because you're not viewed as being one of the persons who actually did the killing. So the actual statute that we have covering this, which is the Criminal Justice Administration Act, indicates that the accessory after the fact is subject to a sentence of a maximum of 2 years.
Okay.
And it is considered a misdemeanor.
Okay, so the major issue now is the accessory before the fact.
Before the fact.
That's the charge with it. If proven, you're going to be treated as a principal.
Correct.
So in other words, if the maximum sentence is life imprisonment, you would also be liable to life.
Precisely.
Okay, so let's brings us now to sentencing, which is going to be taking place in a couple of weeks. What are the things that a judge is going to bear in mind now at a sentencing hearing, such as that which is coming up?
Well, first of all, because it is murder, there are mandatory minimum sentences that the judge would have to impose. That. Precisely. Now, they differ in relation to the Offences Against the Persons Act. How they differ is, looking at murder, if the circumstances that underpin the charges amounted to what is called capital murder, then the minimum sentence is life imprisonment, and the judge would make a recommendation that the person not be released on parole until at least 20 years has passed. Where it is a situation of non-capital murder, then it is again life imprisonment, but the judge can make a recommendation with a minimum of 15 years. And there are also circumstances not often used, where instead of life imprisonment, the judge can sentence the person for a minimum of 15 years.
We use those phrases, capital murder, non-capital murder, and a lot of people not very sure what's the difference.
Well, the actual situation in relation to capital murder is stated and specifically set out in our statute. And what it does is it outlines a series of provisions where if those circumstances are satisfied, it is capital. For example, if a police officer is killed in the course of his duty, that is capital, a corrections officer, a judge, etc. There are other situations. If the murder took place as a part of another felony, a rape, a robbery, it is also capital. Again, if there are multiple killings in a situation like that, it satisfies the elements of being capital. If it is a contract killing, it also satisfies that element.
Okay, and that's the law's way of saying these crimes are regarded as more heinous.
Well,
more serious.
More serious because still they attract capital punishment.
Yes.
Although we hardly see that happening.
Yes, because again, what the law says is, because I know a lot of my viewers will be saying, okay, capital punishment, if we're talking about capital murder, if we're talking about murder, we shouldn't be talking about hanging. We always get back to that.
Yes.
But the law really really very, very severely restricts the circumstances under which capital punishment can be imposed.
It is severely restricted. First of all, even where you have several persons convicted of murder, unless you can prove that this particular person did physical violence to the victim, that person cannot be the subject of the death penalty, what we call the trigger man test. So that in a contract killing situation, the person who is supposed to have instigated the contract could not be subject to the death penalty. Further, the death penalty does not come into play unless the prosecutors give notice that they intend to seek the death penalty. They hardly do that.
Yes, we saw that recently in the beheading case, but
and in that
the
particular
notice was
case, the
withdrawn.
director indicated that because of the post-mortem results that show that the beheading came after death, she would not proceed with it because of the Trinningham case,
Yes.
which says that it has to be the worst of the worst
Yes.
before, in fact, they apply.
And mutilation of a body, meaning after the person has died,
Precisely.
wouldn't be seen as falling into that worst of the
Not
worst
according to
category.
the Trinningham case. In fact,
Right.
after the Trinningham case, it's difficult to see any case
Yeah.
falling into the worst of the worst after that.
Well, that's for another program.
Yes.
I'm going to leave it there. Thank you so much, Lloyd McFarlane. We do appreciate it. And stay with us because coming up after the break, should Jamaican be a language, an official language alongside English? Jamaican, Patois, Creole, we call it different things. Stay tuned for that. Coming up in all angles, Patois,
Yeah, me a throw that
Well, now that me know, next year party too.
Creole,
That's how you pre me, sir.
Alright, so you give money for your staff party, we collect.
Oh, and I throw that for me to go say 8 figures and them thing there. Them say, okay.
Jamaican,
I say, go sometimes when you feel like you're done, you get the best thing. You see me?
You really hope your face nice, so if your face nice, you're ugly. You know that bad looking, you know? You can go on TV, natural.
Me a boss a pool. Ah!
That's nice.
our heart language, but should it be an official language? But first, guilty verdict for Tesha Miller. We'll break down some of the issues in the case.